The first case to come before us this morning is State of Ohio versus Anthony L. Bryant. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're counsel for the appellant and wish to reserve any time for rebuttal, please let me know when we get started. I'm keeping the clock. Please do not mention the names of any victims or minors. We are recording this and it is streaming live on our YouTube channel. We have read the briefs and we are ready to proceed when you are.
Yes, Your Honor. I'm sorry. I did not hear that.
Oh, can you hear me now?
Yes.
Okay.
I just didn't hear the very last part.
Oh, okay. We've read the briefs. We're ready to proceed when you are.
Okay, thank you. I would ask to reserve 5 minutes for rebuttal.
Certainly.
Thank you. Well, good morning, Judge Hensel, Judge Sutton, and Judge Callahan. I'm Andrew Kinder, and I represent the appellant, Anthony Bryant, in this matter. I am not going to go over the facts of this case unless the court wishes me to. The procedural history, I believe, is what is most important in this case. And I also am going to assume at this point that the court is well versed in the procedural history of this matter. With that being said, I do want to indicate that it is not the appellant's position, as we are here today, that the carbon copy counts in the indictment are fatal to the state or the appellee's case. That is not our position. We do submit that they are problematic, and I believe they are bad form, but I don't believe that they are fatal. It is also not our position that a subsequent court would not be able to ascertain what acts the defendant, the appellant, was tried for in this matter. It is our position that no one at this time or during the pendency of this case can determine which count alleged which acts or which act that the defendant appellant, Mr. Bryant, has been acquitted of, or which act has been reversed and remanded. No one can determine which act is contained in which count in the indictment. It is also our position that a subsequent court could clearly ascertain what acts the defendant was tried for and acquitted of. I have found no controlling authority, or any authority, frankly, which speaks to the circumstance in which neither the state nor the court can determine what conduct is alleged in which count. And likewise, I've found no authority that speaks to the circumstance in which the defendant was indicted for 2 counts. He was convicted of 1, he was acquitted of 1, and he was then convicted and later acquitted of a 3rd act. And then the remaining conviction was reversed and remanded. So this is what we're left with in this matter. As I appear today before you on behalf of Mr. Bryant stands convicted of nothing. He was indicted on 2 counts of gross sexual imposition, GSI. The trial court convicted him of 1 of those counts. The trial court ruled that the state failed to establish beyond a reasonable doubt the alleged conduct contained in another 1 of those counts, which one we don't know. The trial court then convicted the defendant of a 3rd act, which this court overruled and he stands acquitted of. And then this court also reversed and remanded the remaining count. And no one knows which count in the indictment, whether it be 7 or 8, any of that procedure that I just spoke of refers to. And I guess to that point, where we have two issues that I see. One, that no one can determine which count the trial court initially convicted Mr. Bryant of, which count the trial court initially acquitted or which act the trial court would initially acquitted Mr. Bryant of, and then which count the trial court found Mr. Bryant guilty of a third act, which was then reversed. We have that issue and the issue of if there are two counts in the indictment of GSI, and there's no argument that he's been, I don't believe there's much of an argument that he's been acquitted of one of those counts by this court, and the trial court found that the state failed to prove the alleged conduct in another count, and that stands as an acquittal as to that count. We've got those two acquittals and two counts. And that is the crux of our second point, that he's been indicted on two counts. He's been acquitted of two acts in which each contained in a separate count. And we don't have any other counts left other than one that was reversed and remanded. But it's interesting that the state in its brief goes to some length to defend the carbon copy nature of the counts in the indictment, and in doing so, the state has emphasized how the counts are distinguishable, and it has and how a subsequent court would clearly be able to ascertain what acts the defendant appellee was tried for. And we agree. We agree with the state's position there. They are distinguishable, and a subsequent court could clearly determine that the state cannot go forward for Mr. Bryant touching RS's anus, and the state cannot go forward again for Mr. Bryant spitting on RS. Those were tried, and he was acquitted of those acts. And that's two acquittals. Now, later in the state's argument, the state emphasizes those points in an effort to defend the carbon copy use, the use of carbon copy indictments. But this is, I believe, one of the problematic aspects of using carbon copy indictments. Are they fatal? No. The courts have clearly said that you can use them. You have to, at some point during the proceedings, differentiate what these acts are what the acts are that are being alleged. The state clearly did that in this case. They elected those acts being the vaginal touching and the anal touching. But it is interesting that, notwithstanding the state's emphasis on the fact that the counts can be distinguished and that a subsequent court can clearly see what counts or what acts the defendant has been acquitted of. Later in their argument, when the state appears to downplay the significance of those acquittals, when it argues that, well, one of those acquittals certainly doesn't bar a retrial on the count that was reversed on evidentiary reasons.
And counsel, you're just now reaching that 5-minute mark, excuse me, into your rebuttal time. So you may proceed or reserve that 5 minutes. It's up to you.
I'll proceed for 30 more seconds or so. Thank you very much. The state appears to want to downplay the significance of the acquittals. When you look at the acquittals separately, does one of those acquittals, the acquittal for the spitting or the acquittal for the anal touching, do either of those separately bar a retrial on the remaining count? No, but together they do. He was charged with 2 counts. He was indicted on 2 counts. He was tried on 2 counts, and we have 2 acquittals. Thank you.
Thank you, counsel. Counsel for the state, you'll need to unmute your microphone. Thank you.
Thank you, Your Honor. So I appreciate opposing counsel's efforts to trim down what's in dispute here and I guess fine-tune throughout all the multiple pages of briefing back and forth to fine-tune what I understand the defense's or the appellant's argument to be, which is that we don't know which count alleged which act or acts, and therefore we don't know which count has been reversed and remanded. Delineating or specifying that we know which acts or conduct have been dealt with and what's at issue right now and what would be at issue on a retrial. It seems to me, unless I'm misunderstanding, that the issue is relatively formal, that we don't know how to fit which conduct to which number, which conduct to which count 7 or 8. Interesting, but I think that elevates form over substance, and therefore, in its own interesting way, overcomplicates an issue that is essentially a non-issue. Because my response to that would be that what the appellant is the issue that appellant is raising is that it essentially brings to light the awkwardness of the trial court's recitation of the procedural history when it reopens the case at a retrial. In other words, the court won't be able to pronounce which count is up for retrial. We are back on the record. This case is on remand. The state chooses to retry one of the counts, and that count is 7. That count is 8. We don't know. Granted, that may be an awkward or unconventional way to resume proceedings or to resume a case for retrial, but I don't think that causes any substantive actual problem in preserving the defendant's appellant's rights at a retrial. I don't think it hampers the defense in preparing or or challenging a case on retrial. The first thing is, wouldn't it be sufficient for the trial court to simply say one of the counts of GSI, gross sexual imposition, remains, okay? And then to specify, as it did in its judgment entry on the motion to dismiss, which is up on appeal right now, to specify essentially what it already did, which is, here are the acts that are not up for retrial. The defendant appellant's penis touching the victim's anus, and the act of the appellant spitting on the victim's vagina. That's out. Okay, we're not disputing those issues. We're not bringing those up again to satisfy the remaining count of GSI. What is at issue is now complying with the rules of evidence and following the suggestions or orders of this court to consider the victim's mother's testimony that it erroneously disregarded. Now that we take that into consideration, did the defendant's act of touching the victim's vagina with his penis, does that qualify as GSI? Everyone knows that that would be the issue in dispute, as it was all along. So in other words, does it really matter that the which count remains of 7 or 8 for GSI? Does it really matter? Isn't it sufficient for the trial court to say one count remains, be it 7 or 8? If that, for whatever reason, is still a problematic enough that something must be done, I suppose this court can provide a remedy to everybody and guidance to say that the trial court must make a decision. This may sound a little extreme. It kind of makes my point, is the trial court could essentially flip a coin and say 8, count 8 remains,
Well,
or count
counsel,
7 remains.
how do you respond to appellant's argument that there were 2 counts of GSI and 2 acquittals?
Well, that's okay, because one of the acquittals, as case law shows, is can be retried without violating double jeopardy, and that is the count, whichever one, 7 or 8, that is the count that was reliant on or dependent on the act of the defendant appellant using his penis to touch the victim's vagina, right? That was reversed on appeal due to evidentiary reasons, and case law provides that that does not preclude a retrial on that factual issue. That would be my response. I hope I addressed your question.
You did.
Okay. And I also hope that I was convincing in doing so, but more importantly, I hope that you understand that hopefully I understood your question. And again, I appreciate opposing counsel's ability right now to help narrow things down, so I don't have to go over all the case law that we cited about the carbon copy indictments being all right. And quite frankly, I think that that dispenses with a sizable portion of both parties' briefs. The portions regarding Ogle, State v. Ogle, the 8th District case, which drew on Valentine v. Conti, the 6th Circuit case. But just to, I suppose, lock that issue up or throw it out, my understanding of those cases was that this might be dicta to an extent, but the force of those cases was that carbon copy counts of the same crime can violate, but don't universally violate the double jeopardy clause on a retrial if the trial court can't distinguish which facts or evidence were applied to which counts, which again, opposing counsel, the appellant has conceded not the case here. But more importantly, State v. Ogle is a persuasive authority, not binding on this court, and it relied heavily, if not exclusively, for that point on State versus Conti, which a subsequent case that is Coles v. Smith basically moderated its own prior holding in Valentine and saying that identically worded, factually indistinguishable indictments or carbon copy indictments are not unconstitutional per se. I think that these briefs now that we have fine-tuned things could have been reduced to about 5 pages. Does the court have any interest in the citations of Ogle and Valentine and how they might apply to this case? And I'll try to address it if the court does. With that, just kind of a side issue that the appellant brings up about that the court erred in not amending the indictment pursuant to criminal 7D, stating that the act of spitting on the victim's vagina was contained in the same count as the touching of victim's anus. Again, the state is not required to set forth an indictment, the factual basis for which a grand jury has indicted a defendant on. That's Weiner. I hope I'm pronouncing that correct. That's what the bill of particulars is for. This indictment was not defective in any way, and therefore the trial court was not required to amend it. So that's my response to that issue.
Counsel, can you speak a little bit more to the issue of the bill of particulars? Because it's my understanding in this case that a bill of particulars was first requested, but later declined by defendant. Is that correct?
That is correct, Your Honor. And to that point, at the trial court, in the briefing regarding the motion to dismiss, the state attached an Exhibit A to its response to the motion to dismiss, and it was an email to trial counsel, Mr. Matthew Malone, in which the state asked, we were going over the docket today and were reminded that you filed a request for a bill of particulars. Now that you have received discovery on this case, do you still wish me to respond to your request in writing? That was from Assistant Prosecutor Angela Wypasek. Defense counsel curtly replied, not necessary, thanks. And also the docket reflects the same. So trial court went through some labors to point out the bill of particulars would satisfy your desire to know which facts are supposed to match which counts. Do it through a bill of particulars. You did it. And then you realize, pursuant to open discovery rules, you don't need it anymore. And he was acting as the agent of the defendant appellant. I think that dispenses with the issue. Maybe it doesn't in your mind. And if it doesn't, I would like to discuss that with you.
And counsel, you mentioned a moment ago the Valentine case, and I would be interested, even though what has been said here today, in understanding how you may believe this Valentine does or does not apply, is distinguished or is not distinguished from the current case.
First of all, it is not binding on this court, as it is a 6th district case. That relies on, it doesn't rely on, it does not apply to Ohio grand jury indictment requirements. That's pursuant to State versus Adams, which is not a binding authority either. That's a 7th district case out of Mahoning County, which then cites to an Ohio State case, though, State versus Burnett. Those cases say that Valentine does not apply to Ohio grand jury indictment requirements. So that's kind of the shorter answer to your question, that there's some case law persuasive that relies on authoritative case law, Ohio State case law, that says Valentine versus Conti just doesn't apply to this situation.
If Valentine did apply, would this case be distinguished from the Valentine decision?
Yes, it would, both factually and principally. For one reason, in this case, all counts identify the same particular date, January 13th, 2018, rather than an 8.5-month period or range under which Valentine was concerned. All right, that's of course factually different, but it has different legal effect because that's an 8.5-month range alleging a variety of counts. And the defense is at a loss perhaps not as much with discovery, but we don't know in that case. It's naturally at a little bit of a loss to figure out what's what. Here, each count was specific to a particular date. Also in this case, there was adequate differentiation between the counts such that a later court could discern which facts were decided at trial and which facts were assigned to which count. Again, the appellant is not disputing that, I don't believe. In Ogle, the state failed to differentiate between carbon copy counts because there were non-specific allegations of abuse over an indefinite number of times. And again, Ogle relied on Valentine. Also in this case, the defendant doesn't run the risk of being retried on facts that he was acquitted of. By reversal on appeal, the defendant was acquitted of GSI due to insufficiency by the particular act of spitting on the victim's vagina. Thus, the parties know which facts will not be elicited or else won't be applied to any crime that the defendant was charged with. So to sum that up, Valentine is distinguishable because it dealt with a broader range of time and less specificity than in this case.
Thank you.
You're welcome.
Counsel, if
Yes.
we could, if I could go back to the bill of particular issue for just a moment. And I realize this is somewhat speculative, but from what I read in the brief, it sounds to me as though if the trial prosecutor would have responded to the bill of particulars, one of the counts, either 7 or 8, would have been touching one area of the victim's body, and the other count would have been touching the other area of the victim's body, because it sounds as though that is the theory that the state proceeded on, and was somewhat surprised about the end result with spitting. So in that regard, I'm not sure how a bill of particulars may have solved this issue for the defendant.
Well, I appreciate you spotting that issue, Your Honor, because that is perhaps something that the state did not drive on as hard in the briefing on this appeal. But you bring up a fair point that are we really focusing on form over substance? Because if the bill of particulars issue addresses the confusion the defense might have, it really wouldn't arguably have addressed the issue at all here, because the trial court kind of went off on its own, which it's allowed to do, as a grand jury is allowed to do, went off on its own and taking certain facts and saying, that actually fits this crime better than what you're saying, state. But the reality is the defense is not arguing. They're not saying that a bill of particulars would have helped in this case. I think the defense seems to be just focused on, we don't know which number count is being remanded and retried. We know the facts. We know what we legally, factually have to challenge. We don't know what to call it, 7 or 8. If we don't know what to call it, that's somehow a flaw that forecloses a retrial, which is a courageous argument to make, but I don't think that it meets the ends of justice.
And
Did I answer
counsel,
your question?
You did. Thank you. I appreciate it.
and unfortunately, counsel, I need to let you know that you have utilized actually just over their 15 minutes of oral argument. Thank you. Counsel for the appellant, given that that we went a little bit over, you'll have your full 5 minutes. You were just under that anyway.
Thank you. Your Honors, briefly as to the bill of particulars, I would submit that it's not a big issue in this matter. I believe that the bill of particulars was perhaps one way to resolve any confusion that the defendant at the time, Mr. Bryant, and his trial counsel would have had regarding what was contained in what acts were specific to which counts in the indictment. But I believe that was cured during the trial and during closing arguments in any event. And I believe that those 2 counts were touching the victim's vagina and touching the victim's anus. That's what was stated during the trial by the prosecutor, and that's what has been acknowledged throughout the briefing process. So I don't believe that a bill of particulars would have addressed the trial court's ruling that somehow a spitting constituted the crime of GSI. And as to the case law in this matter that the court has asked about, my take on the case law is simply that courts do not view carbon copy counts in an indictment favorably. It can cause confusion, and this case is a prime example of the confusion that those counts can result in. This is like a law school exam question, this case. Are we arguing that they're fatal to this case? No, I'm not. Frankly, I believe that Attorney Wypasek at trial set forth distinguished between the two counts. What Attorney Wypasek did not do, she was the prosecutor at the trial. What she did not do is she did not say, these are the acts. This is the act which is contained in count 7 of the indictment, and this act refers to count 8 in the indictment. That was never done. So if we are focusing on the indictments, and Mr. Amir, I think, properly set forth that we were, at least on one hand, focusing on the indictments or on the counts in the indictment. We don't know if it's count 7 that the court acquitted Mr. Bryant of. We don't know if it's count 7 that the Court of Appeals acquitted Mr. Bryant of. We don't know if it's count 8 that the court acquitted Mr. Bryant of. And we don't know if it's count 8 that the Court of Appeals acquitted Mr. Bryant of. We don't know. And if we don't know that, then if he's retried on count 7, or if he's retried on count 8, and again, Mr. Amir has posited I guess the flipping of a coin to determine that. Well, he may be retried on a count that he's been acquitted of.
Counsel, do we know what conduct he was acquitted of and what conduct he was not acquitted of?
Yes, that we know. That we know. And there's the second part of this argument. If we're focusing on the counts, we don't know which count he's acquitted of. But if we're focusing on conduct or focusing on the acts, yes, we know. We know from the trial court's, I believe, October 20th ruling in overruling our motion to dismiss. We know that the court found that the state had failed to prove beyond a reasonable doubt that the defendant, Mr. Bryant, had touched the victim's anus. That we know. And we also know that this court, the last time this case was before this court, reversed and acquitted Mr. Bryant of spitting on the victim. That we know. Those are two acts, two one of them was alleged conduct, the other was the decision of the trial court, but two separate and distinct acts for which he has been acquitted.
And counsel, I
Yes.
greatly appreciate your thorough analysis. Judge Sutton, has your question been answered or no?
Yes, that's fine. Yes, thank you.
Thank you.
Thank you both gentlemen for your reasoned arguments. The court will take the matter under advisement. We will issue a decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website.
Thank you, Your Honor.
Our
Thank
next
you.
oral